I'm going to give an overview of the trial regulation changes to start with, and then I'm going to hand over to Gurmel, who will talk about the changes around approvals, and then we'll both open up for questions at the end. So we're co-delivering this. Some of you may have attended my webinar last year, I think it was, when we were talking about the anticipated changes. We're now in a position where they're in place, and so I'm going to be giving you the detail on that. I'll be putting some useful links in the chat box towards the end as well. So you'll notice I'm starting off with our slide, but these slides that I'm presenting are actually the NIHR slides. That's because I work very closely with the NIHR on developing and reviewing the GCP programme, and they in turn have been working very closely with the MHRA. So this is a slide set created directly with input from the MHRA around what they wanted us to present, and it's the standard national slide set that's being presented across the UK to share this. I've made a few tweaks at the end to make it Welsh centric at the end, but otherwise it's the national slide set. And if anyone wants to present within their teams and share information on these changes, we can share this slide set for you, and it's available for others to then present within their teams as well. So I'm talking, as I said, about the UK clinical trial regulations and also the good clinical practice updates that are coming in. So just to give a background on where we're starting with, so at the moment, until recently, we've been working with the Medicines for Human Use Clinical Trial Regulations 2004. So that's the UK law that we follow specifically for drug studies. And also we're currently working to, when we say GCP, the full title is actually ICH GCP and then a bunch of codes afterwards. So we're working to R2, ICH GCP E6 R2 here. And again, this is legally required for drug studies, but is often used as the gold standard or best practice for all other types of research as well. And what we're changing to is the Medicines for Human Use Regulations 2025. So we've got new UK laws, and the new version of GCP is E6R3, which has replaced E6R2. So what you need to know about the timelines is both of these will be in place, and we are working towards them. The MHRA will be inspecting against them from the 28th of April 2026. Since the 28th of April 2026, that's the deadline that we're working to. At the moment, we are in the middle of a 12-month implementation period with the clinical trial regulations. So they were released in April of this year. They were signed off by Parliament, and we're now in that 12-month implementation period. So we're actually quite fortunate that we're giving that. Our colleagues in Europe are actually introducing the new GCP later this month, and they don't have an implementation period. The MHRA made the decision in the UK to introduce the new GCP alongside the new clinical trial regs and to give us this implementation period to help work towards achieving that. So from that 28th of April, the new GCP principles will be legally required to be complied with for all trials of medicinal products as per the UK clinical trial legislation. So the UK law reflects back the GCP, they're embedded within each other. So why are they being updated? They've been updated because we need to be able to ensure all participants that we include all participants, and we promote the inclusion of underserved populations in clinical trials, aiming to increase diversity. And that's a really interesting point. That maybe hasn't been promoted as well, but we're trying to make sure that by one aspect of these new regulations and the new GCP is to get much greater diversity in our research groups, so that we can actually, have that greater, more valid research at the end that is applicable across the population. It's also there to ensure patients and their safety are at the focus of our trials. Obviously, it always has been, but we're just creating a bit more of a robust situation for them in response to a lot of changes that have come into the research environment and globally anyway, for example, electronic systems, aspects like that. And it's about trying to bring the benefits of clinical trials and research to everyone. Big aspects around it as well. We're trying to create that proportionate and flexible regulatory environment. What that basically means is we're trying to make it a little bit easier to do research. So you'll notice the word proportionate gets mentioned an awful lot. Essentially, if you've got lower risk studies, then it should be easier to set them up and run them. If you've got higher risk studies, then there's additional checks in place so that we can run those safely and effectively, and we can be flexible. With the regulatory environment, that's essentially how MHRA are inspecting us and what we're working looking at too against the laws. It's also part of cementing the UK as a destination for international trials. So it's a big piece of work to make the UK a very attractive place for conducting research globally. And then as a part of that, provides this framework for that, what they're calling a streamlined and agile framework that's responsive to innovation. So as more and more changes do come in to how we work in research, to how we work with our documentation and recording, this regulation allows us to be a little bit more agile, a little bit more responsive to these changes as they come in. So the reasons for the updates are classified into these lovely little boxes that gives a really nice overview of it. So risk-based, I mentioned the word proportionate earlier on. Risk-based, this is one of the biggest changes that's coming in from the UK regulations and in GCP. A few of you that have heard me talk about it before will know that risk assessments are a really big part of this. It's essentially about that proportionate approach to the higher risk studies. We have more things in place to keep us safe. The lower risk studies, we have the things in place that we need that enable us to do it safely but are not burdensome. So it's that risk-based approach, and it's a really big part of it. And study teams having really high quality risk assessments will be a key thing that gets looked at. If anyone's got questions around risk assessments at the end, please feel free to ask and I can go into more detail. It's also around that innovation. So it's around encouraging more modern trial designs. I'm sure many of you, particularly during the pandemic, came across lots of very different trial designs that maybe you weren't used to, working with decentralized methods, aspects like that sort of. So it's about that innovation. We're also looking at consistency as well. So aligning our UK regulations with the global standards. So that's why the UK regs have been updated to reflect the updated GCP, but also to make sure we're working to that higher standard globally. We've mentioned flexibility. So again, that risk proportionate approach comes in there to allow really good, high quality trial oversight that is proportionate to how that study needs to be run. So we've got that, there's more flexibility in it than there was before. Efficiency is another one as well, which is something Gurmel will be talking about much more, but it's about streamlining some of these regulatory processes to basically make it easier for us to set up and run these studies and reducing some of that administrative burden. And a large part of that is what Gurmel will be talking about later on. Data integrity, obviously, we're all very familiar with the fact that technology has taken quite a few leaps and bounds in recent years, particularly within our research studies. So how we can ensure robust data governance practices are there. So it's basically taking the principles that were there already and just making it a little bit more robust to reflect those the different the ways that we're managing our technology, our data now, to really make sure that legislation is tight for it. And again, that goes hands in hand with that technology as well. So not just how we're managing our data, but maybe different digital tools we're using in our research studies as well, and how that's managed. And then I mentioned inclusion at the start. So that's one of those key points that was listed at the very start. The MHRA were very keen on us talking about that. They're trying to really promote diverse participant recruitment strategies to improve generalizability of our findings. Research is defined as something that is generalizable. We should be able to take the findings from our research studies and generalize it to the whole population. And so having that more diverse group enables that much more so. Okay, so this kind of gives a general overview of the main areas of change. I won't go into great detail on any of this because I could take a whole day if I did do that. I would love talking about it, but you might not. So these are what the HRA and the MHRA are referring to as the headline changes. So approvals is one of the big areas where changes are coming in. Obviously, I'm going to leave Gurmel to talk about that in much more detail. But again, it's part of that process to make it easier and more streamlined to get studies set up and running, especially that risk proportionate approach, so that low risk studies that don't carry any greater risk than usual care. It should be much easier and quicker for us to set them up and for the MHRA as well. Transparency is one of the big areas of change coming in as well. So as part of that, the new regulations will require all clinical trials to be registered on a public registry. So previously, all trials had to have a UDRACT number. Obviously, post-Brexit, that's not as relevant. So we're still managing that, but it's been updated. So they have to be registered on a WHO registered public registry by either the date on which the participant is recruited or 90 days after that approval. So it's on there. We were already doing that anyway in different formats. It's just, it's written into there. But it's also, as part of transparency, the sponsor will be required to publish a summary of results on that same public registry within 12 months of the trial ending. It is possible to request to extend that period for certain reasons, but only up to a certain point. It is also possible to have a waiver for that, but that would be for exceptional circumstances, such as national security considerations. So it's highly unlikely that would be anything we were coming across there. There's also a requirement under that transparency to offer a summary of results for participants in a suitable format, so basically in lay language. And I think this is something that, from speaking to a lot of colleagues, that's an aspect that I think we really need to be aware of when funding studies, when creating studies, because we need to make sure our teams have the time to create those. It's often the case that when a study comes towards the end, we move on to the next study, and this bit is quite challenging, getting that message out at the end. So it's a really positive step, particularly for our participants and our members of the public. Safety reporting and pharmacovigilance, so there's quite a lot of changes in there, but a lot of this is more around sponsors' responsibility than sites' responsibility. And again, it's about sort of streamlining and removing duplicate reporting requirements. So at the moment, sponsor does have some duplicated safety reporting requirements that actually they've shown doesn't actually improve patient safety or patient safety monitoring. So trying to make that simpler for sponsors to manage that. So instead of listing serious adverse events and reactions in the annual safety reports that sponsor sends out to PIs, then there will be a discussion on how safety concerns were evaluated and addressed. So it just makes it, we're still managing that safety, but it's in an easy way for sponsors to manage, and it is trying to streamline and make things easier. And it also ensures that safety reporting is proportionate to the risk. So obviously higher risk studies, we've got much greater vigilance in place there as well. And then there's also updates around consent. So the updated regulations include the ability to use what were called simplified means of seeking consent in lower risk studies. So again, a study that doesn't carry any more risk than usual care, do we need to go through the same level of rigorous consent discussion and documentation as we would, an early phase 2 novel drug study? And it's that balance there, because it can be very challenging for sites to set up these low risk studies if they've got to go through these long processes, and it can be challenging and confusing for patients. If I was going to be prescribed this treatment anyway and you want to collect information on it, but in order to do it, I've got to read this 10-page information sheet, but if I don't do the study, I still get it and I don't have to read the information sheet. So it's that simplified consent in very specific formats. If anyone is attending the support and delivery day next week, I'll be running a workshop specifically on simplified consent. So there'll be some information there. And again, if you've got any questions on it, do let me know at the end. Ultimately, though, the revision is there to support a streamlined and flexible approach to the regulation of trials. Again, it's about removing that unnecessary burden, that administrative burden that's there. So we've got that risk proportionate approach to make it easier for trial sponsors and also those running the studies, but it's also maintaining that protection for our study participants. So these are the proposed. So guidance is coming out. So the HRA and the MHRA have and are writing guidance for us to support that, because it's recognised that the clinical trial regulations, the laws there, are written in legal speak essentially, and actually a lot of people just want something really clear written out on how to conduct the research, step by step. I want something really clear here. So the HRA have actually just published their guidance information on this, and I'll share a link at the end for you that's available online. And the MHRA are still working on their guidance documents as well, which should be coming out later in the year. But again, I'll share a link with you at the end for some of the draft information they've put out there already, so you can get an idea of it. But it's these are the proposed guidance topics. So this slide was created just before the HRA released theirs, with input from MHRA. So they've got the broad guidance, where it's sort of looking at, how we get those new GCP principles in, what risk proportionality is and risk assessment, so that broad guidance on it, and sponsor responsibilities and oversight. Then we've got specific guidance around archiving, labeling, and radiotherapy, and then there's explanatory guidance as well. Okay, so I'm now just going to quickly look at some of the changes in our landscape as well. So there's some terminology changes that it's important to be aware of. This one has been a very, very long time coming. As some people might be surprised that GCP, Declaration of Helsinki, the trial regs, everything was still referring to our participants as subjects, even though on the ground, I don't think any of us would ever imagine referring to them as almost subjects here. So that has updated, which has been needing to update for a very long time, because we don't subject people to our research, they participate in it. Trial site is changing to trial location, which is again just recognizing the fact that when you're working remotely, it might not be a physical site. So trial locations be updated. Amendments are changing to modifications, and I know that Gurmel's going to talk about this later on. That's just to be aware. There's a terminology change there. Essentially, there's very similar sort of processes and thoughts behind it, but terminology change around it as well. And essential documents change into essential records. And that is, again, there to recognise that a lot of our documents aren't hard copy documents anymore. They are, electronic records. So it's just to create that bit more robustness around what constitutes essential records, essential documents. So it's just a terminology change there. Some people are already adopting these changes already, so it's useful to bring it in. But I believe this is probably the one where if people aren't aware amendments are changing to modifications, you might get worried it's something new. It's just the new terminology for it. A big aspect that the MHRA are very keen on as well is what they're calling critical to quality factors. And that's specific areas in the study that focus attention, it's the factors that focus attention on aspects of a trial that have the greatest impact on participant safety, data integrity, and credibility of the results. It's essentially linked to that risk proportionate approach, that risk assessment. It's highlighting those specific aspects of a study where we've got to have those considerations. Where does the risk lie? What are those critical to quality factors for patient safety, for data quality? And it's directly linked to that risk proportionality. So that's a term you're probably being heard spoken about quite a bit. And if anyone is MHRA inspected, that is what are the things they will be looking for. One of the other changes that's coming in is the list of who can be an investigator on a clinical trial. So previously it was quite a limited list. It has now become a much greater list over who could actually be a principal investigator. It's with a caveat that obviously they need to be suitably qualified to be able to do the role, and it has to have been ethically approved in the protocol. We couldn't just, protocol, if protocol says it has to be a medic, it has to be a medic. But this provides that greater opportunity for different types of investigators. Also, being aware of what local policies may be as well within individual health boards or organisations around who and who cannot be an investigator. But this is a really long time coming, this update, and a lot of people are very happy about that. Obviously, as we said, that caveat there, the investigator should be appropriately trained to undertake that role in the trial, so they have to have that. And if they may need appropriate support from medical decisions in regards to the trial. So that's written in there as well. So there are requirements for that. And again, sponsors will be detailing that in protocols. If they're allowing other investigator roles, these requirements will be there. And it's the sort of thing sites would be monitored and inspected against. There's specific timelines to make you aware of here. So urgent safety measure reporting, so this is relating to sponsors, is increasing to 7 days. This is to bring it in line with other countries who were allowing that again, and it's to make it a little bit easier for sponsors to manage that. But they would still be expecting that initial phone call within the 24 hours. It just gives that slightly longer time frame to get it reported through to MHRA. The lapse of clinical trial approval. So after 24 months, clinical trial approval will lapse if a trial has not recruited anyone. And again, I think that's something Gurmel might be mentioning later on as well. Archiving changes. So we're moving to, it was 15 years. So archiving requirements were 5 years for all clinical trials. If that product is then licensed for use, it was increasing to 15. This is increasing to 25 years. So that is updating there. Request for further information deadline, so that's changing 60 days from when notice given. Again, that's something Gurmel will look at. And we mentioned as well, when we have to register a trial in a public database, it's either before the first participant is recruited or 90 days after approval. And again, as I mentioned at the start, if we're publishing the summary of trial results, it's a requirement to do that within 12 months of conclusion of trial. But there is opportunity to apply for an increase in time for that if required up to a certain point. The key one that the MHRA have really asked us to focus on as well, though, is obviously that importance of risk. That was a key objective for the revision to the regulations, and really reinforcing that risk proportionate approach, because we don't want to make it too hard to run those EASY studies, but we do want to make sure we've got that the checks in place relevant to the level of risk in a study. And the focus on that is obviously on the protection of the right, safety and well-being of the people taking part in our study. And again, it relates back to what we call those critical to quality factors. You may also be aware that the Declaration of Helsinki has updated. So that was updated towards the end of last year, and that has directly fed into GCP, which has directly fed into the UK clinical trial regulations, and it forms the ethical basis for good clinical practice as well. So the changes in Declaration of Helsinki, you'll see again exactly how this has fed into all the other changes. So they've changed participants, they've changed from subjects to participants, and they've also put greater protection in place of vulnerable groups. So you can see that that's been translated across. They've also promoted what they call meaningful community involvement. So they've actually had quite a lot of input around the social value of research as well. They've recognised electronic and ongoing consent. So again, it's part of that robustness I mentioned. A lot of the updates are there to reflect the fact that we are using electronic systems more, so to make sure that the existing guidelines and regulations are fit for purpose for using electronic systems. Principles remain the same, but it's making sure it is relevant to it. It emphasises scientific rigour, ethical oversight and open data sharing. Again, so that open data sharing directly translates into the increased transparency that we're seeing in the UK. Pushes for equity and research benefits and broader inclusion. Again, you can see that that's come in with that the top statements around trying to increase diversity and inclusivity in our research trials participants. And it also addresses AI, data privacy and digital ethics. And the Declaration of Helsinki does update, quite regularly. So this was an expected update, and as I said, we've updated in response to it. So that's a very quick overview of the main areas that are changing and the things we need to prepare for. The MHRA have said that whilst we're in this 12-month implementation period, they will be inspecting against the old GCP R2, and then they're inspecting against the old UK clinical trial regulations, and they won't inspect against the new ones until 28th of April next year. But if you do have an inspection in this period, what they will be looking for is what things people may have in place to prepare for those updates when they come in. So they won't be inspecting against it, but they do want to see that teams have got things in place they're preparing. And then just a little update on your GCP training. So GCP, as it stands, GCP training, within GCP, there is no specific guideline on how often or when people need to update their GCP. That's often a local or sponsored decision where people are required to repeat every 2 to 3 years. However, it does say in GCP, if there's any significant change, it is required to update. So it will be a requirement for people on clinical trials to update their GCP. Now, at the moment, the NIHR are working very, very hard on updating all of their GCP material. You can see from this slide, there's quite a lot available. So directly available on NIHR Learn, and we do have facilitator-led courses as well. I'm sitting on the working group that's reviewing this, and we're getting direct feedback from the MHRA. We don't have a date yet of when we'll be able to release these because we're waiting on the MHRA to finish their guidance and give input to us, but we will be releasing updated training available as e-learning on NIHR Learn and as facilitator-led, whether that's in person or virtual, depending on local need. So those will be released UK-wide as well, and that will be directly related to the new GCP. So we will make sure that you hear about that. The NIHR have set up a very good comms strategy, and our comms team are working closely with them on that, so we'll keep you updated. It's also important to advocate here what we call the proportionate approach to GCP, which you may or may not be familiar with, but this was a statement that was released by the MHRA and the HRA in 2017, basically recognizing that there's a lot of people, historically especially, who were being asked to complete GCP training who maybe didn't require it. I often give people the example, I had a taxi driver, all he was doing was driving blood samples for a study around Cardiff, and the sponsor required him to attend a full day's introduction to GCP with me, and the poor guy looked terrified the whole time he was in there. So they're trying to remove, I mean, that's an extreme example, but it did happen. So they're trying to make it the proportionate approach. So if people are in, very limited roles in a study, they don't. Then their training is proportionate to their level of involvement in the study. So the different options available. Obviously, we've got the introduction to GCP and the GCP refresher that the NIHR run, and then related to that introduction to GCP, we also run what we call a GCP consolidation as well. It's an optional extra for people who've completed the e-learning that want to get a little bit more information on it. There's awareness training for people that fall into what we call the awareness group. So that's people who are maybe working in a research environment, but they're not directly involved in it, or they're conducting their normal duties, nothing different to what they would do normally. And that data happens to be going into a research study. So there's different e-learnings available on NIHR Learn for these groups, whether they're working in a clinical setting or out and about in the healthcare or community settings. And in Wales, we also have what we call our research awareness fact sheet as well, that's available for people that meet this awareness group that you can use for internal in-house training, and you can store that in a site file as evidence of the training that's there. So that meets that awareness group. And then there's also what we call the GCP fundamentals available on NIHR Learn for people that work in labs or pharmacy. For those that are maybe doing a very limited role in a study, there may be someone who's leading on the research study in labs or pharmacy that guides them on it. But if someone's just doing like one small part of the study, then they can complete the GCP fundamentals instead of completing the whole study. And that's all available on NIHR Learn, and there's a lot of information on there. But just to say, the main sort of takeaways that we're being asked to share with people is we're keeping our website updated, but if you do log into NIHR Learn to keep updated with the training options available, there's a lot of really useful information on there. We do recommend actually reading the clinical trial regulations and GCP itself if you can. I'll share the links when Gurmel's speaking. Then again, attending webinars like this, discussions to stay informed, keeping people trained, particularly as you have new people coming in, and ensure you've got key change control places in place. But the key takeaway we've been asked to share is just to use this lead time until the 28th of April next year to read up, to review any internal processes, make any necessary adjustments, ensuring that compliance within your teams, and work with sponsors to develop a consistent approach. Here's some of those useful links I've mentioned, but I will put them in the chat for you as well, so that you can access them there. I'm going to hand over to Gurmel now, and then if you've got any questions at the end, we're happy to answer them.
Lovely, thank you, Kat. I'm just going to get my slides ready to share as well. Hopefully you can all see that. Kat, I can see your face. Can you give me a nod? Is that okay? You can see that? Okay, I'll start by giving an apology. Kat introduced me to the laser points. If I do get excited, I'm sorry about it. So Kat, thank you kindly for the introduction. So I'll be talking about the changes, updates to the clinical trial legislations. Just to start off with, on the 28th of April this year, the United Kingdom and the Northern Ireland Assembly approved the Medicine for Use Clinical Trial Regulations 2025. This is by feedback from the public consultation, which was held in 2023. So as I move forward, I'd like to say that the following updates in this presentation have been approved and shared by the HRA, and it's also available at the link at the bottom of the slide. But similarly to Kat, I'll put the link in the chat function after my presentation, and I'm more than happy as well to take questions towards the end of the presentation too. So following that link, from the previous slide, you'll be presented with this page, which offers the current guidance on the changes to the clinical trials and regulations, and I will aim to cover these changes at a very high level in today's presentation. I must stress that these changes are from the 28th April next year, but we thought it'd be really beneficial to the forum here to offer what is coming. So the first change is the introduction of 3 new definitions, as you can see on screen. So the first one being a non-investigational medicinal product. It's a medicinal product that will be used in a clinical trial as described in the protocol, but not as an investigational medicinal product. The second being a notifiable trial is a trial with no significant safety concerns relating to any of the investigational medicinal products, as far as the sponsor is aware, having made reasonable inquiries. And then the public registry is this is defined as a primary or partner registry of or a data provider to the World Health Organization International Clinical Trials Registry platform, provided that the registry or the data provider facilitates public access information about the trial in the United Kingdom. The second change that I'll be talking about is about pharmacovigilance. I know that briefly Kat touched upon this. So as of next year, the safety reporting requirements for CTIMPs will change. These will only be reported to the MHRA. If any ethical issues are identified by the MHRA when they receive the reports, they will liaise with the Ethics Committee directly. And the period a sponsor has to give written notice to the REC and MHRA for an urgent safety measure will be extended. Instead of the current timeframe of 3 calendar days, they'll have up to 7 calendar days from taking any urgent safety measures to give written notice. The third we'll be looking at is regarding the approval process for CTIMPs in the UK. So new clinical trial regulations will result in changes to the approval process for clinical trials of investigational medicinal products in the UK. These changes will come into play, as mentioned, the 28th of April next year and apply to all CTIMP applications and modifications, as Kat mentioned, previously known as amendments, submitted from that date. Applications and amendments submitted before this date will follow the current process and legislations. So if you submit a CTIMP application before the 28th April 2026, it will follow the current approval process, legislation and timeframes. Any CTIMPs that you submit on or after the 28th April 2026 will follow the approval process and timeframes set out in the new trials regulations. The following sections will give you guidance on how your CTIMP applications will be processed from that date next year. So on screen, albeit very, very small, you can see the timeframes and process, which I will break down over the next few slides and hopefully give you a bit more clarity. This is where I get to have fun now with a little laser. So once the submission of the CTIMP application has been made, this starts the validation phase up here of the application. The validation stage of the process is where the MHRA will have 1 day to validate the study, and the applicant will have 6 days to respond to any queries, totaling the maximum 70 calendar days here. So once the application has passed that stage and is valid, the MHRA and REC will conduct the initial review. This includes the application being discussed at a full meeting of the REC. The MHRA and REC will complete the initial review as quickly as possible, and the outcome will be shared with the sponsor and relevant individuals listed in the application by email within a maximum of 30 calendar days of the application being confirmed as valid. So some of you may be aware that there are various outcomes, as you can see on screen. I just want to capture that the last one being unable to issue an opinion is also known as a provisional opinion. So on this screen here, we're looking at the if the REC are unable to issue an ethical opinion after the initial review, it will email the sponsor to request further information. The request will be sent as soon as it's been confirmed by the REC, which means that the sponsor will be able to receive and consider feedback from the REC as soon as it is available. When the new clinical trial regulations come into force, the sponsor will have up to 60 calendar days from when the request is sent to respond. Sponsors can respond as early as they would like to within those 60 calendar days. The sponsor should not include any changes to documents or information that are not in the response to the points raised when they respond to requests for further information. Reviewing a response to the request for further information, it has a maximum of 10 calendar days. The MHRA or REC will receive the response from the applicant to review and issue the final combined decision, which is right here. So from next year, again, going back to Kat says, all approved studies will no longer be called amendments. So any change, etc., will now be referred, well, from then be referred to modifications. On screen is the modification timeframe, and once again, I will expand on each section, offering a bit more clarity. So initially, and it's very similar to the CTIMP full study application, the applicant will submit a modification. This begins the validation stage of the modification, where the MHRA will have 1 day again to validate, and if there are any queries, the applicant will have a total of 6 calendar days to respond to the MHRA, and they will confirm if the application is valid or invalid. So as you can see here, totaling the 7 calendar days. Again, like full applications, once the application is made valid by the MHRA and or REC, they will conduct an initial review and offer a decision within 35 calendar days, pending if a request for further information has been requested. So new clinical trial regulations will allow the MHRA and REC to request further information when considering substantial modifications. This means that if the MHRA or REC identify issues that prevent a substantial modification request from being approved, the sponsor will be informed of these issues and will be able to respond before a final decision or opinion is issued. Requests for further information for substantial modifications will only be issued in a minority of cases where it's not possible for REC to give a favourable opinion or favourable opinion with conditions. If a request for further information is required, it will be sent within 35 calendar days of the substantial modification request being confirmed as valid. If a sponsor receives a request for further information, they'll have a maximum of 60 calendar days to respond. And if a sponsor can respond at the point within the 60 days timeframe, that'd be fantastic. They're able to do that. If they do not respond within the 60-day timeframe, the substantial modification request will not be authorized by the MHRA and will be given an unfavorable opinion by the REC. So once a sponsor submits a response to request for further information, the MHRA and or REC will decide the outcome within a maximum of 10 calendar days. Under the new clinical trial regulations, the REC and the MHRA can request that sponsors modify their clinical trials. This differs to urgent safety measures where a sponsor or investigator takes appropriate urgent safety measures to protect participants against any immediate hazard to their health or safety without prior authorization from a regulatory body. These requests will be made in cases where the MHRA or REC is made aware of the following concerns. So, for example, the clinical trial does not comply with conditions and principles of GCP, the safety of the clinical trial, the scientific validity of the clinical trial. So if the REC receives concerns raised by a third party about ongoing trial, they'll initially contact the sponsor to notify them of the concerns and begin a discussion regarding the validity of concerns raised. If the REC determines that a modification needs to be made, they'll issue a request to the sponsor. So when the new regulations do come into force, again, all CTIMs submitted from this date will be expected to recruit their first participant in the UK within 2 years of the trial being approved. I know that Kat briefly covered this as well. So this will also apply to trials involving advanced therapy medicinal product. If a trial recruits no participants within 2 years, the approval for the trial will lapse. In this scenario, the sponsor will have to end the trial and submit a notification in writing by the end of that approval lapse. Continuing to run a CTIMP after the approval has lapsed would be considered an offence under regulations. If the sponsor submits a CTIMP application before the 28th April 2026, this expectation will not apply. So therefore, this means that the approval will not lapse, and if the trial does not recruit its first participant within 2 years. So the fourth change, we will look at the new clinical trial regulations in terms of the offer sponsors of these trials to meet certain conditions, with the options to use simplified arrangements for seeking and evidence-informed consent. The new legislation is designed to reduce a burden and increase flexibility while safeguarding participants. We want to see greater adoption of this proportionate approach, which is supported by the new legislation for the benefit of the patients. So moving on to the fifth change, which is regarding the Ethics Committee. The new regulation will update the minimum membership requirements for RECs that review CTIMP studies. So from the 28th April next year, each REC must have an appointed chairperson, a minimum of 5 members in total, which include the appointed chairperson. We'll continue to make sure that the number of committee members in all RECs is sufficient so that full meetings of the RECs are quorate. So to be able to review a CTIMP under the current regulations, a full REC meeting must have at least 7 members, including an appointed chairperson present to issue an opinion. So finally, the last change to share is the research transparency. So these are requirements for clinical trials, which require the sponsors of CTIMS in the UK to register a clinical trial in a public registry before the recruitment of the first participant or within 90 days of approval of the clinical trial. So whichever comes sooner. The publish of a summary of the results within 12 months of the end of trial, and to offer or to share a summary of the results with participants or relevant individuals. I think this was briefly also covered by Kat as well. So the big one is, I was going to do an image of dangling the carrot, but I thought, no, it's going to come soon. Some of you may be aware that IRS is changing. It is a work in progress, and I'm hoping that both myself and Kat in the future have the opportunity to present in an oncoming webinar what those changes are. But just to put it on your radar, IRS is changing. So that being said, I'd like to say thank you. This is the link I'll put in the chat as well, so you will have that for information. I think the slides may be shared too. And just a shameful little plug right at the end if you want to get in contact with me for any approval queries or any ethics queries. Thank you so much. Thank you.